Any marriage they would attempt to enter into during that 30-day period would be voidable under Kansas law. So wait at least 30 days past your decree's filing date to attempt to enter into a new marital relationship.
A long-term marriage heads for a structured end, as Tristan and Joshua Niblett enter court with a full settlement already prepared. It sounds smooth, but every clause still needs judicial approval. Will everything hold up under scrutiny? Stay tuned for every twist and subscribe for more gripping courtroom breakdowns.
Settled in the matter of the marriage of Tristan Gail Niblett and Joshua Seth Niblett, case number 2025 DM222. Starting with petitioner, would counsel announce their appearances for the record, please?
Joshua Andrews on behalf of the petitioner Tristan Niblett, who is present with me in my office.
Susie Locke on behalf of the respondent, Joshua Niblett, who appears via Zoom separate and apart from counsel.
This matter is set for further hearing today. Mr. Andrews, what is your position regarding the current status of the case?
Your Honor, we have reached a comprehensive settlement agreement, and we are ready to proceed to final hearing at this time.
Very well. Then I trust you'll be calling your client as a witness?
Yes, Your Honor.
All right. The court will administer an oath to Mrs. Niblett at this time. She'd raise her right hand. You do solemnly swear that the testimony you're about to give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. You may question the witness, Mr. Andrews.
Thank you, Your Honor. Please state your name for the record.
Tristan Gail Niblett.
And Tristan, you are the petitioner in this case, correct?
Yes.
Were you a resident of the state of Kansas for at least 60 days prior to filing the petition for divorce?
Yes.
Were you and Joshua Niblett married in 2005?
Yes.
Have you remained legally husband and wife since that date?
Yes.
Do you believe that the two of you are compatible to remain husband and wife at this time?
No.
Do you believe that is going to change in the foreseeable future?
No.
Is this incompatibility based upon irreconcilable differences?
Yes.
Are you asking for the court to grant an absolute decree of divorce based upon this incompatibility?
Yes.
Do you and Joshua have minor children?
Yes.
Have you entered into an agreement with Joshua regarding the care, custody, and support of the minor children?
Yes.
Specifically, have you agreed that the two of you will exercise joint legal custody and divided residency of the two minor children?
Yes.
Specifically, that you will be providing the primary residency for the minor child whose initials are LJN, and Josh will provide the primary residency for the minor child whose initials are SJN?
Yes.
Have you agreed that regular parenting time will be from 7:00 p.m. on Thursday until Sunday at 4:30 p.m., with weekends being defined as the Friday to Sunday, and Thursday exchanges being modified to accommodate any Friday school schedule?
Yes.
And that Joshua will receive that parenting time on the second weekend of every month, and you will receive that parenting time on the fourth weekend of every month?
Yes.
And that at all other times during the school year, the custodial parent will have the respective child unless otherwise agreed upon by the parties?
Yes.
Have you further agreed that parenting time exchanges will take place at an agreed upon location on the north side of Bentonville, Arkansas?
Yes.
Have you agreed that in the event there is a move by either parent, that this first could be considered a material change in circumstances allowing for the review of this residency plan, but also that you and Joshua will agree to a new exchange location halfway between your new residences?
Yes.
Have you also entered into a comprehensive agreement regarding the parenting time for holidays and school breaks?
Yes.
And is this set forth in a decree of divorce and settlement agreement that you have fully reviewed and already signed?
Yes.
Have you further agreed that the two of you will encourage and ensure regular school attendance for the minor children, and that if one of the children is absent from school, then the custodial parent will communicate that absence to the non-custodial parent in advance, which includes the date and reason for the absence, unless the absence is unplanned, in which case the custodial parent will communicate the length and reason for the absence as soon as feasibly possible.
Yes.
Have you further agreed that effective March 1, 2026, Josh will pay child support in the amount of $832 per month?
Yes.
Do you believe that the terms of this agreement are in the best interest of your minor children at this time?
Yes.
Have you also entered into a comprehensive agreement regarding spousal support, the division of marital assets and debts, and how income tax returns are going to be handled through 2026?
Yes.
Specifically, have you agreed that Joshua will claim the minor children on his tax returns for 2023, 2024, and 2025, and that the two of you will be filing married but separate for those 3 years?
Yes.
And have you agreed that each of you will retain any respective tax refunds and or be solely responsible for any respective tax obligations for those years?
Yes.
Then have you agreed that commencing with the 2026 tax year, again, you will be each filing individually as you will be divorced this year, and that Josh will claim the minor child whose initials are SJN in every tax year, and you will claim the minor child whose initials are LJN in every tax year?
Yes.
This is where financial accountability gets real. Both parties accept full responsibility for debts in their own names, from vehicles to credit cards and loans. Legally, that limits future disputes, but it also locks them in. Do you think this clean split truly protects both sides moving forward financially?
Have you further agreed that neither of you will have a spousal support obligation?
Yes.
Have you further agreed that you will be awarded as your sole and separate property, free of any claim by Joshua, any and all bank accounts in your individual name, your Chevrolet Traverse, the Kelly McClaskey oil royalties, the Citizen Bank of Kansas checking and savings accounts, the White Eagle Credit Union savings account, any other financial accounts in your name, and all other personal property in your possession?
Yes.
And that Joshua will retain as his personal property, free and clear of any claim of you, all financial accounts in his individual name, the 1992 Jeep Wrangler, 2011 GMC Sierra 2500, Polaris four-wheeler, dirt bikes, three-wheeler, Kubota tractor, Monticello account, Campus Credit Union account, White Eagle Credit Union account in his name, all other vehicles in his possession that are not otherwise listed, and any other personal property in his possession.
Yes.
Have you further agreed that you will assume sole obligation of all debts associated with the vehicles in your possession, including any loan payments, insurance, and taxes or registration, the Nelnet student loans, filing fee tax obligation, and any penalties for your individual 2023, 2024, and 2025 tax returns, the White Eagle Credit Union recreation loan, Wells Fargo debt, any debts and obligations incurred since the date of the separation, and any other debts and obligations in your individual name?
Yes.
And have you agreed that Joshua will assume sole obligation for all debts associated with any vehicles in his possession, including loan payments, insurance, and taxes and registration, the Kubota tractor debt, the 2011 GMC Sierra repair costs, the filing fee tax obligation, and any penalties for his individual 2023, 2024, and 2025 tax returns, the Discover credit card, American Express credit card, MasterCard credit card, Commerce Bank credit card, Capital One credit cards, Wells Fargo credit card, and any other debts and obligations in his individual name?
Yes.
Do you believe that the terms of this property settlement agreement are fair, just, and equitable?
Yes.
Are you asking the court to adopt these as the final orders of the court in this matter at this time?
Yes.
Finally, are you asking to have a prior name restored?
No.
Your Honor, I have no further questions.
Ms. Locke, do you have any further questioning of this witness?
No questions for this witness, Judge.
Very well. Mr. Andrews, do you intend to present further evidence?
No, Your Honor.
Ms. Locke, do you?
Judge, I would proffer to the court that my client has reviewed the journal entry and accepts the terms. I can call him as a witness if the court would like to hear testimony.
Not necessarily. If he's already signed off on a settlement agreement and decree of divorce, that would seem to speak for itself.
Yes, Judge.
All right, very well. And the court finds from the evidence that has been presented and from review of the file that the parties are incompatible and that the petitioner shall be granted a final decree of divorce from the respondent on the legal ground of incompatibility. The marriage of the parties is hereby declared to be dissolved. Court further finds that the parties' agreements regarding a parenting plan in this case and the child-related issues certainly appears to the court to be consistent with the current best interest of those children, and the court will adopt the parties' parenting plan and make those the orders of the court. Court further finds that the parties' agreements regarding property and debt certainly appear to be fair, just, and equitable to both sides. The court will approve those provisions and make those the orders of the court as well. I'll point out to the parties that they're not divorced based on this oral pronouncement from the bench, but rather when the decree of divorce is actually signed by the judge and then filed with the clerk. It's the filing of the divorce decree with the clerk's office, which is the legal act that divorces you under Kansas law. And then for a period of 30 days thereafter, neither the parties should try to remarry. Any marriage they would attempt to enter into during that 30-day period would be voidable under Kansas law. So wait at least 30 days past your decree's filing date to attempt to enter into a new marital relationship. I give credit to each of the parties in working out a plan that keeps both of them actively involved in the lives of their children, arranging for some long distance travel and some accommodation. They are to be given credit by the court for reaching those agreements, and I hope that they can always continue to work together for the best interest of your kids. Good luck in that regard. Mr. Andrews, is there anything else particularly that the court needs to address at this hearing?
Not that I'm aware of, Your Honor.
When do you project the decree will be submitted into the court's signing queue?
Your Honor, the decree was actually prepared by Ms. Locke, but I'm going to be scanning and emailing later today. Later this morning, the journal entry has been signed by me and my client, so she should have that later this morning.
Okay. So, Ms. Locke, I trust that might even be submitted to the court's approval queue today?
Yes, Judge, as long as I have all of the signatures, I should be able to get it filed today.
Very good. The sooner we can get this wrapped up, the better. Ms. Locke, is there anything further that you believe the court needs to address?
No, Your Honor.
I apologize to the parties for getting started late. We had some technology issues on the court's end, which hopefully will get resolved now, but I appreciate your patience. Good luck to you in the future. If there's nothing further, the Niblett matter will currently be in recess at this time.
The judge finalizes the divorce on grounds of incompatibility, approving custody, finances, and property exactly as agreed. But the key detail, this isn't official until the decree is filed, and there's a 30-day remarriage restriction. A clean legal ending, yet a complex personal chapter closes. Like, comment, and subscribe for more.